Okay, it looks like we're up to stroke now. My name is Rupert Butler, and I'm a barrister practicing at Three Hare Court as well as at Leverett's Barristers and Solicitors. And I'll be introducing the seminar this evening along with Natasha Jackson of Three Hare Court, who was junior counsel in the proceedings, the official receiver against Camila Batmanghelidjh and others, which we're going to talk to you about this evening.
Evening, everyone.
So the purpose of our webinar is to talk about our recent experience representing Camila Batmanghelidjh in a 10-week trial in director's disqualification proceedings that took place this autumn. If you've got any questions that you'd like to raise throughout, then please feel free either to email us, and if we don't pick them up during the webinar, we'll come back to you later. Or if you want to go through the chat room, we'll try and pick them up as we go and either deal with them as they arise or at the end. This was a very unusual case for all sorts of reasons, and we'd like to give you some of the particular insights into it. The first unusual feature about it was that it was director's disqualification proceedings that were directed at the officers of a charity. So you had the chief executive officer, who was Camila Batmanghelidjh, and originally 8 other trustee directors, although that number fell down to 7 when one of them gave undertakings. There was also one single allegation that was made against everybody, and that was that they were operating an unsustainable business model. Now, fans of 20th century opera may recognize the quote at the beginning. It's from Porgy and Bess. It's Porgy's ode, "I got plenty of nut and nuttin's plenty for me." I'm not going to sing it to you, but this was on Natasha's and my closing submissions to the judge as our opening remarks, because it sort of summed up where we got to after 10 weeks, was that we still weren't quite sure what the whole thing was about, but what we did feel was there wasn't a lot in what the official receiver was saying. In order to give you a fair presentation, we need to actually give you a bit of the context, the background to Kids Company. And you may recall that in 2015, this charity, which had been the darling of David Cameron and many high net worth celebrities and philanthropists, collapsed amid sexual abuse allegations. Sexual abuse allegations which turned out to be completely unfounded. And these allegations came just after it had received £3 million in emergency bailout funding from Her Majesty's government. And this led to a really violent media attack on the charity and its officers, particularly against its charismatic founder and chief executive, Camila Batmanghelidjh, and the BBC's creative director, Alan Yentob. And even when the judgment was published, on the 12th of February 2021, we still found that some sectors of the media, particularly those that had originally attacked it, found it very difficult to accept that this was anything other than some sort of piece of legal trickery or magic that had happened, that had somehow allowed these people who were clearly culpable of something very bad to get away with it. And so we found forked headlines and statements in the newspapers, such as the Daily Mail, which gave the impression that somehow these people had got away with it.
Yeah, and we've got from the Daily Mail comment section on the day of the trial, some nice balanced commentary there. But it wasn't just the right-wing press that was putting this kind of content out there. We can see from the Mirror, there was a focus on the cash crisis within the charity and the sexual abuse allegations. And we've seen a comment raising the amount of taxpayers' cash that has been considered to be trialed to £46 million. We then have from The Guardian as well, similar commentary focusing this time again on Camila being the celebrity at the centre of everything. And in that comment there at the bottom, a report from 2016 by the Commons that was focused on more negative findings than the judge had just made. So, as Rupert said, Kids Company was a frontline children's charity that collapsed in 2015. And it was established as a charitable company, which means that it was regulated under the Companies Act 2006, as well as under charity law. And as Rupert suggested, it held a very strong place in the public imagination, particularly so because of Camila, who was the founder of the charity and our client, who You can see there on the left of the slide. But before we talk about the trial and the nuts and bolts of the matter, I think Rupert's going to do a bit of a straw poll on some of the media publicity surrounding the charity around about the time of its fall. So I think, Leanne, if you're able to bring the poll up.
We thought we'd test what you think you knew about the charity. And so if anybody would like, they can fill in this and hit send at the bottom. And we'll see, test your prejudices. So off you go, everybody. It's 4 or 5 questions there. It shouldn't take too long. Because one of the problems we faced throughout our time representing Camila Batmanghelidjh and throughout the proceedings was that the whole thing was conducted with an air of suspicion about everybody, that there was something that had been going on that people had a sense wasn't quite right, but they weren't too sure what it was. And so much of this had been fed from extremely negative and prejudiced reporting that had happened at the time of the charity's collapse and for some time afterwards, until eventually Alan Yentob was effectively forced to quit his role at the BBC because of complaints that had been made around his apparent or alleged influence over journalists in their reporting of the charity. So Leanne, when you've got the results in, if you can publish to us as many as you have, we'll see what it is that people tend to think, tend to believe. Okay, so here are the questions. Kids Co gave money to children to buy drugs and trainers. Is this true? 90% think it's true, 81% think it's false. Well, what is true is that Kids Company did give money to children. It was £30 normally a week as an allowance, and it was intended to help them turn their lives around. Of course, some of the allegations were that kids who were some of the worst and more difficult kids to reach for the charity did in fact spend it on drugs and trainers, but that certainly wasn't what it was intended for. 2, Camilla lives in a mansion with a private swimming pool. 22% think that's true, 78% say that's false. There was a large, almost derelict house that had been bought for use of the kids with a charitable donation specific for that purpose, and it did have a small, largely broken outdoor swimming pool that was used for therapeutic purposes. But Camilla never lived there. She continues to live in her same flat in West Hampstead she's lived in for 20 years. So that was another false one. Kids Company was audited yearly. 89% say yes, 11% say false. Well, that's true. It was audited, and it was audited by charity specialist auditors, as well as regularly being audited by the government in order to assess whether or not it was suitable to carry on receiving the grants that the government had given to it. Have we got more questions there, Leanne?
I think maybe
and answers.
If you scroll down a little bit, Rupert, you should be able to.
Oh, is it? It's down to me, is it? Okay.
But the next one is Camilla drew a salary of £90,000 paid for by government grants. So we've got 41% saying true on that. False is 59%. But it is true that Camilla was paid a salary of £90,000, but I think that was paid by a particular donor who made a donation that was intended particularly to cover her salary. And that was after that donor had been appalled by how low it had been.
It's also worth bearing in mind that £90,000 for a charity chief executive these days is well below the market rate. Go on, Natasha, give us 5 and 6.
5. So we've got Camilla had a chauffeur whose children went to private school paid for by Kids Company. We've got 22% there saying it's true and 78% saying it's false. So it is true that there was an employee of Kids Company who was employed to do operations work for the charity. And from time to time, he did drive Camilla, but that certainly wasn't what he was employed to do. And he had children with special needs who were beneficiaries of the charity. And the charity did pay for the attendance of one of those children at a particular school. So there's a bit more truth to that than perhaps the audience thought. But as framed, that is another myth that can be busted. And then, Rupert, do you want to take number 6, which is that Camilla and the trustees trousered taxpayers' monies for themselves? Which,
well, this is the critical one. 16% say yes, 84% say false. Now, some of you may recall that there was another director's disqualification case not so long ago called Fairpack, which was all about the Christmas hampers savings company that collapsed into insolvency. And that also received high degrees of negative press attention, although it didn't have anybody quite as charismatic as Camila and Alan at its helm. So it was more targeted at the organisation rather than the individuals. But the representatives in that case also suffered from the prejudice that had been probably propagated in the media that wasn't fair or wasn't true. And we found that this was a continual theme that kept haunting us in this case. And it's important to bear in mind that the official receiver of Kids Company had the books and records of the company for 2 years. No separate office holder was appointed. And in all that time, with all that scrutiny, all that was presented to the Chief Executive Officer and the trustees was a single allegation of an unsustainable business model. There was no suggestion of any impropriety, no lack of integrity, no dishonesty, no lack of probity. It was simply about the way that they ran the charity. There wasn't one single item of financial expenditure that was criticised for being contrary to the charity's objects. And that stands to reason when you think of a charity of this size that was turning over more than £20 million a year and was subject to regular external scrutiny. And yet still, the media thinks that it is able to make highly critical comments about the way that the charity spending was operated. And it's worth also saying that the Charity Commission has announced since the end of the trial that it's not going to bring separate proceedings against any of the individuals involved.
Okay, thank you. Now I've been able to close down the poll, but I think in case it's still on everybody else's screen, Leanne, if you could just end the poll there. And we've got here a comment from Mrs. Justice Falk, who was our judge for the hearing, making it clear, just as Rupert said, that to someone whose familiarity with Kids Company might have been gleaned from press reports, the conclusion that I have reached might appear to be a surprising one. However, I make my findings based on all the evidence I have read and heard over the course of a lengthy trial. So I think that brings us on to talking about the case. Now, as Rupert said, this wasn't a case in which there were any allegations of dishonesty made at all. The case essentially fell into two parts. The case under Section 6 of the Company Directors Disqualification Act 1986 was the unfitness case, which, as Rupert just said, was based on one single allegation, which is that the trustees and Camila operated an unsustainable business model. And as a result of that, the official receiver's case was that all of the trustees and Camila ought to be disqualified. Now, the unsustainable business model allegation was hugely important, as Rupert indicated, to the course of the trial, because this was such a broad and unspecified allegation that this was the root of many issues that troubled us throughout, to do with fair presentation of case, amending allegations during the course of the trial, and these are things that we'll come on to talk about in the course of this presentation. And point one on the slide is the threshold allegation against Camila, because for the case to succeed against her, the official receiver had to be able to make out that she was a de facto director, because of course, as CEO of the charity, she wasn't a trustee or a director within the meaning of the Companies Act, unless the official receiver could make out that she was acting in a position that she wasn't registered to perform. So over to you, Rupert, to set the scene.
Okay. Yes, so when you've got an allegation as broad as an unsustainable business concept, then of course it requires some degree of packaging in order to make it possible to try. And in this case, the official receiver packaged it by picking a moment in time about 2 years before the charity folded, and then effectively decided to review every single facet of the charity's operation from its financial management perspective in order to see whether or not it will, or in order to try and prove that the business model it was operating was unsustainable. So in a charity of this size, you can imagine that it creates a very large amount of information, data that needs to be analysed by the court and reviewed in front of the witnesses in order to test whether or not that allegation can be made out. And that's why we ended up with a 10-week trial this autumn. And it's worth pointing out some of the logistical issues that we had in running that, because it started on the 19th of October. We were in the middle of the pandemic. Infection rates were rising throughout the land, and about the 3rd of November, I think it was, we went into our second national lockdown, although the schools stayed open. Now, many of you as practitioners will have become familiar with conducting your hearings remotely, but some of you may not have seen a 10-week trial in a pandemic conducted in a courtroom, but that's what it was decided should happen. The reason being that director's disqualification proceedings, unlike any other civil proceedings, don't provide for a remedy, they provide for a penalty. In that respect, they're often described as quasi-criminal. And so it's necessary to have in front of the judge the witnesses in person, if possible, to judge their demeanour. And that's why it was felt that it was necessary, if possible, to get everybody into a courtroom. So 4 weeks beforehand, we had a pre-trial review. Very strict timetable was set for how witnesses would be examined and the time that would be taken. And we also had to provide for a socially distanced super courtroom in the Rolls building, courtroom 15. There are only 3 super courtrooms of a particular size that could accommodate a trial such as this. And there had to be provision for this trial to be heard in person and, if necessary, to go remote should the national guidelines change on social distancing and lockdowns, but also for some people to attend remotely if for whatever reason they became incapacitated, unable to travel, vulnerable, whatever it may be. This was a trial that attracted a high amount of press interest. So because there wasn't enough room in the courtroom we had to accommodate all of the parties and their legal representatives, there had to be a separate courtroom dedicated next door, courtroom 14, as a public gallery and for the press. In order to make the trial technically possible, we used the Opus 2 platform, and at a cost of about £700,000, there was provision for audiovisual technicians to be in court who could then stream the proceedings live to any location that the court, that the judge allowed. We had live transcription services, fully digitized electronic bundles, and a live evidence presenter who would bring up the documents onto screen for people to observe and be questioned on. And at any one time, we had about 65 screens operating in court for the 20 participants who were allowed in, which was effectively just the parties, legal advisors and the courtroom staff bringing in witnesses as and when they were needed. 3 of the witnesses gave evidence remotely, 2 because they were vulnerable, including Camila, and unable to travel, and 1 because he was in Hong Kong and unable to meet the quarantine to get in and out of Hong Kong and carry on doing his job. We also had the unusual situation of the judge having to self-isolate twice during the course of the trial, once because a member of her household tested positive, and once because a member of the court staff tested positive for coronavirus. And in the course of the trial, we also lost her clerk and her judicial assistant at times. We had the unusual situation of Camila Batmanghelidjh giving evidence into the courtroom from her home via closed circuit television, and the judge also being remote, giving her directions to the court and listening to the evidence from her home, whilst we were all in the courtroom listening intently. And if there had been any little green men from Mars up in a spacecraft looking down on Earth for intelligent signs of life, they almost certainly wouldn't have found it if they'd seen us all bowing to an empty TV screen every time the judge left for the short adjournment.
Yeah, she didn't bow back, she just signed out. But I should also be clear, the clerk and the judicial assistants were fine. We didn't lose them full stop. They just had to isolate for a little bit. But so I just skipped over my pantomime graphic there. She's behind you. So I'm going to talk a bit about the case against Camila on de facto directorship. So the title here encapsulates a lot. The official receiver's case against Camila was largely that she was a sort of pantomime villain, larger than life character who was the face of the charity and pulling the trustees' strings behind the scenes. And hopefully that's a perception that the myth busting of the media perception has already unsettled a bit. But we were meeting a case against Camila that was very much based around her personality and what the official receiver said that meant for her control over the company and the decision-making process. Now, as I think Rupert indicated earlier, this case was breaking new ground in respect to the fact that this was the first case in which a CEO of a charity was being alleged to be a de facto director, full stop, not only within the course of directors' disqualification proceedings. So we were meeting a case in which the context in which we're normally operating when considering de facto directorship allegations is the commercial context. And it's very common for CEOs of commercial companies to also be company directors. But trustees of charities under charity law, it's section 185 of the Charities Act 2011, are not able to be remunerated for their position. So necessarily, they often operate a different structure. Smaller charities may well have board members who are very active in the executive day-to-day management of the company or charity, but that's nearly impossible for larger charities like Kids Company that routinely require full-time salaried management staff in order to function. So thankfully for the charity sector, Mrs. Justice Falk agreed with us that it cannot be the case that any charity CEO who's essentially performing a role like that of a commercial CEO and is good at their job must be a de facto director. And the implications of this would have been huge otherwise, as it would have meant charities doing so would have been a breach of charities law, a breach of that provision that prevents remuneration. The test in respect to de facto directorship is the test that many of you will be familiar with. It's set out there on the slide. We've got repay check, which is the leading case in the House of Lords then was, which Peter Knox QC, who I think is speaking in our next seminar for the Insolvency series, was counsel in. And then we've got the Court of Appeals decision in Smithton and Nagar. And in short, these cases set out that there's no singular test for de facto directorship, but whether a person is a de facto director will depend on the corporate governance structure in question and the decision-making structure within that company. So in this case, Mrs. Justice Falk didn't reinvent the wheel, but found that the trustees, being non-executive trustees with paid staff, that this context was all relevant to the factual situation that she had to look at and the corporate governance structure in question. And as a result of this non-executive structure, this required a significant level of delegation to Camila as CEO.
Now, we at Three Head Court Leverett find ourselves often acting for and against office holders. So what our approach here is talking you through these various points is to try and look at it from both sides of the case and how one might go about checking whether or not somebody is a de facto director. I think this is important because I anticipate that even though this case did not succeed for the official receiver, it will not necessarily be the end of similar occasions where the courts are asked to investigate in the context of not-for-profit or charities whether or not a CEO or other senior management team are in fact the real directors who are running the company. And remember, the test is somebody on an equal footing with the other directors so that they are part of the main governing structure. And one of the reasons for setting out this checklist as we've done, some of which may seem almost statements of the obvious as to where you might go for your sources of evidence, is that there was a feeling that the official receiver in this case had not really drilled down into the background of this charity and studied carefully its entire corporate governance structure from its outset to see what roles people fulfilled and whether or not anybody could be truly described as a chief executive officer. So, for instance, the articles of Memorandum of Association are a good place to start to look and see, particularly in a charity, what its objects are, what the powers and duties of the trustees are, different from a trading company, and see how it is anticipated that the trustee board will be able to employ staff and delegate their functions, the executive functions, to other people. And it's worth just pausing here as an aside to say that in this case, the official receiver conceded in evidence that he'd never been a director of a trading company, had never been a trustee of a charity, and had never brought such proceedings against charities before. And so everything was presented in a somewhat two-dimensional way in which there was nobody of any practical experience appeared to have had anything to do with the decision-making about how to frame the case and how to pursue it. And maybe that's an important lesson for us all, particularly when acting for office holders, is sometimes in order to sense check everything that is done, it might be a good idea to bring in people from the outside, but who have relevant experience in a similar company, to actually say, look, what's going on the ground here? As we look back at the books and records, we've interviewed various people. Does this stand up as an unsustainable business model, for instance, or does this demonstrate that the CEO was on an equal footing in the governance structure? However it may be, but simply trying to do it by a bland reading of the books and records could be misleading. And I think in this case, it did tend to mislead the official receiver's investigating team. So you start with the governing documents. Then you look for things even like the contract of employment, the job description. We found in this particular case that within Camila Batmanghelidjh's contract of employment, there were a number of tasks which had been by contract delegated to her, which it was her obligation to perform in the fulfillment of her duties, which was claimed against her to be evidence of her de facto directorship because she had performed them. And it was important then to differentiate what she was doing because that was her job and what she was doing because she was may have been part of a governing structure. In this charity, which was extremely well run, by the way, and that's something that's worth emphasizing, it had a very sophisticated management structure and senior management team. There were a number of policy documents that were published and amended from time to time, which gave clear indications as to where the lines of reporting were, what the delegated functions were, and from which one could see what it was that people were doing and why they were doing them. We also had instances here where people it had been said, holding themselves out as directors, particularly Camila Batmanghelidjh. And we entered into that age-old problem of what does the title director mean? Because lots of people in organizations are given on their business cards the title of director, but it doesn't mean to say they're part of the corporate governing structure. And here we had a number of instances where documents had been presented to people within the charity who had signed someone else's words and found themselves signing in a box which appeared to give them authority, in which there may have been underneath it a description, either chief executive or director or secretary, and people had simply failed to score out and properly identify in what capacities they were signing. And it became important then to look at the context and the intent behind signatures and behind documents, and to see when people were signing in these ways, were they actually holding themselves out as part of the governing structure on an equal footing, or were they simply exercising some ostensible or actual authority that they'd been given, in which nobody was misled. Just to give you an example, when the government sent out its grant offers, they were often signed by Camila and returned to the government, and the government had a pro forma which it asked her to complete. And it was the government's own words at the bottom, chief executive stroke director. And she simply signed in the box because she was the chief executive, but nobody had given any thought to whether or not she was actually a de jure or de facto or shadow director. It was just something that was there on every form, went out to every charity that was offered a grant. No one was misled, but the official receiver decided that that was a badge of de facto directorship, for which he should then be held liable for all the fiduciary duties of a de jure director, and then amenable to the penalty of disqualification. Board minutes, again, this was an interesting company because unlike many that go into liquidation, where office holders will be familiar with the problems of trying to reconstitute books and records out of almost nothing. In this instance, there were very sophisticated board packs that were put together before each board meeting by the finance director. The human resources got involved, fundraising principals got involved. Camila Batmanghelidjh occasionally had some input into the board packs as well. These would go to the board meetings upon which the trustees would then debate. In this instance, I think it's fair to say that the minutes of the meetings were not as good as they might have been. In fact, they were striking in that they weren't as good as everything else that went from the everything else that was organised in the charity. Perhaps that's because the responsibility for that lay with the trustees, not with the senior management team. But as it happens, those minutes, in fact, contain many clues as to what were the actual lines of reporting, whether or not it could be accurately describing Camila as holding herself out as part of the governing structure. Those minutes needed to be scrutinised carefully in order to see where power really lay. Another curiosity in this case is that when the official receiver had the whole suite of affidavits from all of the defending parties, it didn't seem to be at all moving in the way that the case might be put, so that there was no reaction or response to the fact that with one unanimous voice, even though there were 4 different defending legal teams, with one voice, all of the trustee directors made it quite clear they did not regard Camila Batmanghelidjh as a de facto director on an equal footing with them. They regarded her as subordinate to them, who was acting on their instructions. Some of them found her to be strong-willed, some of them found her even to be unreasonable, but they were clear that they expected a chief executive officer to have those qualities. And it didn't mean that in any way that their free will was overborne. It just meant that she needed careful managing. Then we had an interesting debate, a sort of dislocation of thought between the official receiver's case and everybody else, when it was trying to be suggested that when Miss Batmanghelidjh, when Camila pushed back on things that the directors were asking her to do and doing her own thing on some occasions, that this in itself became de facto directorship, even though it appeared to be contrary to what some of the trustees may have wanted. We then entered into an interesting debate. Where is the difference between insubordination of an employee and directorship? And can somebody who's doing what appears to be the opposite of what the actual trustee board want them to do, does that elevate them to the level of a trustee director, a de facto director? Or does that simply mean that they might be slightly Bolshevik in these circumstances and need more management than they were getting?
Thank you. So there's no black letter distinction between the duties of a director of a charitable company and those of a non-charitable company under company law. But Mrs. Justice Falk agreed with the defendants that the charitable context is nevertheless crucial to the factual circumstances that must be considered when identifying the scope of the duties owed by the trustees. And you can see in the middle of the slide there, charitable context is key. The case of Reed Bearings number 5 is referred to by the judge in the judgment because that case provides authority for defining the scope of the duty of trustees in any company by reference to their status as a director. Now, non-executive or executive directorship is not a legally defined term, but it's a helpful badge that we use to understand the nature of trustee or directorship that particular positions are carrying. And in this case, we had non-executive trustee directors, as we discussed in relation to the de facto director allegation. And we also had unpaid volunteering directors. And that authority was relied upon by the judge as authority for coming to the conclusion that the charitable context is very relevant to the scope or extent of duties that are owed by trustees taking on a charitable role. And there are strong policy reasons in favour of this approach. It can be easily understood that there's a strong risk of scaring people off from volunteering to take on trustee positions, particularly professional people who have a lot to lose as a result of disqualification proceedings. So there's a general concern about a sort of chilling effect that having too wide a definition or too wide a scope of duties for a charitable trustee would lead them away from taking on those roles to begin with. So the effect of this finding is that it could mean that a finding of unfitness that would be attached to a commercial director in a commercial context, incompetent conduct that may merit a finding of unfitness for a commercial director in a commercial context may not necessarily lead to the same conclusion in a charitable context. So there we go. A charity trustee may not be unfit where a commercial director would be for the same conduct.
Before the case came to trial, but as soon as I got instructed, I was sufficiently alarmed to tell all my chums who were charity trustees or governors of schools or involved in not-for-profit to immediately resign and think very carefully before taking on any other roles, because it struck me that the consequences for them could be so severe if this case had succeeded. Another thing I suggested that everybody might want to do as part of their due diligence before taking on such a role is ensure that there was robust directors and officers insurance in place in the event that there was ever a claim under the Directors Disqualification Act, so that they had some indemnity that could respond, because the costs of these proceedings are so overwhelming and the consequences are so severe. And just looking at the role of directors and whether they're in trading companies or non-executive, I think it's important to just consider, because in this case there was another oddity, is that the official receiver had proposed, as is common, different periods of disqualification for different directors. And the highest period of disqualification that was sought was 6.5 years against Camila, even though she wasn't even a de jure director, and on every organisation chart and family tree of the business was sitting below the trustee board and its structure, and yet she was the one who was singled out for the greatest culpability, which was very strange in a case where there was no suggestion of dishonesty or lack of probity or integrity. So we had a range of 6.5 years at the top, down to 2 years at the bottom. So this was in the sort of mid to serious range under the Seven Oaks Stationers categorizations. And yet the official receiver could not articulate why he was seeking different periods of disqualification for different directors. And that was something for which he did come in for quite a degree of criticism in the judgment. And it's worth us all as practitioners bearing in mind that whenever we're acting for or against office holders, we need to identify the basis upon which people are acting as directors and work out their different roles and responsibilities. Who have they delegated their functions to? Are those people capable? Are they entitled to rely upon what they are told by them? How much time is the director giving to the organisation if they're non-executive in a for-profit organisation or non-executive in a not-for-profit organisation? That seems to make a difference as to the extent of their possible culpability. And were there any particular responsibilities that they took on in their role? For instance, did they have a particular skill or reason for being on that board, which meant that they were expected to say or do particular things in respect of the charity's functions or the company's functions, and then look at the extent to which they fell down in undertaking their responsibilities, and should that sound in a particular period of disqualification or not.
yes, also I suppose whether they took on any particular hats within that board, so whether they joined any particular committees like the financial committee or management committee, which could obviously give them greater responsibility attached to their role. So the case was particularly notable for the very strongly worded judicial observations that were given on requirements for fairness and balance towards defendants, and the stark recommendations that Mrs. Justice Falk issued on case presentation and future disqualification proceedings. And we've got there at the top the refinelist case, which is a guiding case on this issue, which emphasises that the official receiver's obligations are not to overstate the case against the defendants, put the case in a fair and balanced way, and give defendants proper notice of the substance of the case they face. So Rupert, I don't know if you want to talk a bit about.
Yeah, and these proceedings are really, really tough on directors, and I think there's been a feeling for a long time that directors do get completely overwhelmed by the prospect of directors' disqualification proceedings, and very often capitulate quite early and give undertakings because they simply can't bear the prospect of being taken through the judicial process. And so for that reason, it's particularly important that the official receiver doesn't become over-exuberant in his task and seek to effectively nobble people. And there was a bit of a feeling in this case that the official receiver was a bit out to get the trustee board, and that is reflected in the judgment. It's certainly reflected in the submissions that were made, but it also finds its voice in the judgment. And I suspect that refinalist will not become a footnote in history, but I think this judgment, which is a really excellent judgment by the way, well worth a read. I'm not just saying that because we won. It's a fantastic piece of judicial prose and hugely conscientious work by Mrs. Justice Falk. But I think this decision will also become a benchmark for the way in which proceedings are to be pursued. And we had some unfortunate issues within it. The way the investigation was pursued by the official receiver meant that certain key witnesses were not interviewed at all. Other people were interviewed more than once. Sometimes we didn't get transcripts of their interviews, and we got some transcripts of interviews within the proceedings themselves. There were occasions where disclosure, and disclosure had been massive in this case in terms of what had been attached to the reports, but where exculpatory evidence existed in the company, but hadn't been brought to the attention of the defendants, and only came to light when there had been targeted requests for disclosure. And even then, sometimes requests for disclosure were not always honoured. There was a huge amount of documentation that Natasha's put there on the side, 18,000 pages of exhibits for a tangential allegation. That was one report, which was about 250 pages. The main report from the official receiver was well over 450 pages. This secondary report was 250 pages on and contained an exhibit of 18,000 pages, which included the records of many of the service users of the organisation. And it was an unbelievably challenging exercise to go through that, even trying to work out why that evidence had been put in the first place. As it happened, when we got to trial, the evidence wasn't even pursued. And yet everybody had to spend hours and hours and hours of lawyers' time turning pages, trying to look through and finding out what all of this meant to the case. Then a particular concern was, and this is part of the overstatement, is that the official receiver, and I'm sure in good faith and trying to do the right thing, had picked out of various reports quotations to include in order to make points, but had risked and failed sometimes to put the full context and sometimes even the full quote, which meant that when the thing was looked at in the round, it could be seen that a very different meaning could be applied to what it was that the official receiver was trying to impress upon the parties and the court. And this sense of unfairness, I think, really was brought out by the failure of the official receiver to react, to flex, to bend in any way when he received the evidence of the defendants, because that should have put the thing in an entirely different context. But unfortunately, once he let the handbrake off the juggernaut, it was just rolling down the hill and all the way to trial. And there was nothing that was going to stop this case other than a judicial determination.
Yeah, I'll just add to what Rupert was saying about the exhibits there, and those being largely documents relating to the data of the children, and that caused a whole additional complication, because obviously that's very sensitive information, and so we had a lot of concern in the run-up to trial in the opening days about how to protect the children in question from jigsaw identification, and a robust protocol had been put in place at the PTR. So that was a rather large kettle of worms. I always do that, can of worms or kettle of fish that was boiling at the start of the trial because of that exhibit relied upon. So this feeds into the issue of case presentation, and I'll be quite brief with this slide because I know that we want to leave time for questions. But the official receiver in the skeleton argument that was received about a week before trial introduced a number of new allegations, so allegations of voidable preference payments under Section 239 of the Insolvency Act, and allegations of breach of duty under 172 to 174 of the Companies Act, that had not featured had not been particularized in the initial report or the subsequent reports relied upon by the official receiver. So much of the first week of trial was spent with argumentation as to whether or not the official receiver should be allowed to pursue these new claims that were added in the skeleton argument. And as you can see on the slide there was a partway judgment. The case reference, I think, isn't there, but I can put it in the chat when I've stopped screen sharing. But there was a partway judgment, which for anybody engaging in cases that raise these issues does contain some quite interesting and new judicial observations about the relationship between Rule 3.3 of the proceeding rules and the CDDA. And in this instance, Mrs. Justice Falk declined to allow the official receiver to bring these new allegations, but did, by contrast, during the course of the trial, allow the official receiver to develop the case put against Camila in respect of de facto directorship. So you can see in the partway judgment and in the final judgment two contrasting scenarios on when the judge considered that it might be appropriate to allow new or amended allegations at trial. So we can happily take any more questions about that, but I won't take up more time now talking about that particular issue.
I see a question popped up for us. Was a compensation order sought? And the answer to that is no. On the finally here, we just talk about the difference between the Insolvency Service and the Charity Commission. I think we had in this case the wrong regulator in the wrong court, to be frank. This was something that was far more amenable to the Charity Commission than the Insolvency Service. One of the reasons being that Camila Batmanghelidjh would have been susceptible to regulation by the Charity Commission under the Charities Act in a way that she's not, unless she could be found to be a de facto director under the company director's disqualification proceedings. But as a matter of policy, and it may be that the pandemic will change what I'm about to say, but certainly before we went to trial on this, there had been a feeling that the government wanted to professionalise charities, to avoid them falling by the wayside through mismanagement, ill management, amateurishness, whatever it may be. And that part of the work of the Charity Commission and the Insolvency Service was to create precedents to discourage other people by imposing better principles of governance upon anybody who was participating in not-for-profit. Of course, the pandemic may have changed all of that, because there are so many charities in such severe difficulty that it may well be that it's going to be impossible to chase them all down and find out those that have failed just through unfortunate circumstances, and those who failed in circumstances where they shouldn't have done but were simply poorly managed.
Yeah, and then just to finish up, we've got a quote, a concluding quote from Mrs. Justice Falk, and you can see there, "It is vital that the actions of public bodies do not have the effect of dissuading able and experienced individuals from becoming or remaining charity trustees. Disqualification proceedings or the perceived risk of them based on wide-ranging but unclear allegations of incompetence rather than any want of probity, carry a high risk of having just that effect, and great caution is therefore required. Which brings us to the end of the talk, but we'd happily take any questions if you've got them. I'll stop screen sharing and we can have a look and see.
Yeah, I see there's a questions come up as to there were 3 ex-staff who gave evidence against Kids Company on behalf of the official receiver. And the question is, could I please ask why there were no witnesses called to give evidence with reference to, for example, clinical practice? I think the answer to that is that in the end, there was no allegation that the charity wasn't fulfilling its charitable objects, and part of its charitable objects were giving money and support and interventions to some of the hardest people to reach in society. And I suspect that there would have been, it wouldn't have been a 10-week, we would have what, a year-long trial if there had been a competition between clinical experts as to whether or not any particular spending was justified in any circumstances. I think that would be the answer to that. But that was a decision made by the official receiver.
And there's another question here, Rupert. What is the position of the trustee director who presumably felt compelled to sign a disqualification undertaking, acknowledging that that is perhaps confidential?
Well, yes, the question could sometimes be, is it possible to vacate a plea like that after the event? And I think the only way you might be able to do that is by, during the currency of a period of disqualification, going back to court and saying that circumstances have changed, you should now be relieved of that undertaking. But unfortunately, in the case of the director who did give the undertaking, it was for 2 years. By the time the matter came to trial and judgment had been passed, the period was over. So I think that would be academic only.
Yeah, agreed. There was another question asked earlier on. Do you have any sympathy at all with those bringing the case? Could any legitimate fact-finding or investigative objectives have been met in some other, more cost-efficient way? That's a very good question.
Natasha, you have a go at answering. I didn't think what I feel about that.
Well, I think obviously there was a lengthy investigation, and I think the impression that Rupert and I shared during the course of the trial was that it was a case that was brought because there had been an expectation that there was something to find under the hood. And in the investigations that took place before the trial kicked off, we could see that there were certain people who were interviewed and were followed up with. So there were certain individuals in question, in particular, who had complaints that were raised against the charity who'd worked there, and they all gave evidence to the official receiver's inquiry. However, there were a number of people who weren't interviewed in the course of that investigation. For example, a finance officer who had been in position for a significant period of time. And I think that obviously an investigative process is necessary, but it seems like perhaps the approach taken in this particular investigation was one guided by an objective that there might have been a necessity to pursue proceedings at the end of it. And if a more balanced and fair approach had been adopted right from the start with an intention to actually understand how the charity worked, then it could have been that a different investigative course was followed. I don't think that necessarily addresses the cost efficient side, but I suppose if you conduct a targeted investigation from the start and maybe also be willing to part with aspects of the claim that aren't borne up by the evidence. So for example, the issue relating to kids costs that we identified earlier, that had 18,000 pages worth of an exhibit to support a claim that ultimately went to a very tangential aspect of the trustee's duty to supervise clinical care, are things that didn't need to be pursued to trial. And I think having that kind of balanced and cost-effective and proportionate mentality from the start could have made the investigation look a bit different and may well have resulted in no trial at all.
I do think I think the official receiver fell into the trap which even the Parliamentary Public Accounts Committee fell into, was that they everybody bought into the mass hysteria. And I think that that tended to leave a subconscious bias in everybody's minds, which meant they thought that they were going to find, as Natasha said, something really smelly under the hood. When they didn't find it, they didn't really appear to feel able to let it go.
Thank you. And we've got another question here. What was the final adverse costs liability of the official receiver, roughly? Presumably not indemnity costs.
We don't know yet. We haven't had the hearing, 26th of March. But I think if we work on an assumption that if you bring proceedings like this and you lose them, then you're going to face an adverse costs order, then I think given the scale of it, it's safe to say it's going to be measured in the millions.
Yes, I think there was a journalist from Third Sector publication who did put in an FOI about the cost of the litigation for the official receiver. I can't remember the figures off the top of my head, but I think if anybody's interested in the legal costs, certainly for the trial, I think they are available on Third Sector's publication.
Then we've got a question, is there an issue for the sponsors of not-for-profit companies? I don't think that this case would give rise to any issues for sponsorship, but I think that any case like this, of course, is going to be generally dissuasive of people wanting to get involved in charities if they think that they're not going to be well run or they're at risk of falling over. But of course, all of that negativity hit Kids Company long before it collapsed. There were some investigative journalists who thought they'd uncovered something wrong with it and wrote about that extensively, generally wrongly, and that was what started to turn donors off giving money. But this was a charity that said, we're doing a job that government should be doing, and it should be centrally funded. And that had always been their position. And every time they went to the government for money, they made that position clear. And they had reason to believe that the government was going to make central funding available on a large scale. But unfortunately, that promise never got fulfilled for a number of reasons. And so private donation was still what it relied upon. And eventually, when people made allegations, unfounded allegations of safeguarding issues on their premises, in the same year as the independent inquiry into child sex abuse was announced by Theresa May when she was Home Secretary, the donors just fled. It was by then a toxic brand, and nothing could recover from that.
Yeah, I think the only thing I'd add is that I don't think the judgment in itself has any direct implications for sponsorship, but of course, something in the minds of sponsors will be concern about charities being well managed and well regulated. And I think the comments made about the appropriate jurisdiction for regulating charities is something that the sponsors may be taking away from this case. They'll want to see that they are firmly under the jurisdiction of some kind of regulatory system. And this case is quite clear in showing that both the charity law and company law can regulate charities, and identifying where perhaps the best, which is perhaps the best suited to wear that hat. So I can see that we've reached 6 o'clock. I think Rupert and I are more than happy to stick around and answer any further questions if there are any, but unless there are any further questions that you'd like to ask, if we call this webinar to a close now, and thank you very much for attending.
Thank you.